substantively on the book, so I really do not want to take up any great time. I'll just make kind of three very brief opening points. I think perhaps, well, I hope everybody, but certainly many, many people recognize that when we are thinking now about the international legal order, about global order, there really is a pressing need to escape from the shadow of the post-Cold War world, and even more from the shadow of the so-called global liberal order of the post-Cold War world, and to set our understandings in a broader and longer-term historical perspective. And that when we do that, and I think as this book so wonderfully illustrates, what we see is that so many of the kind of taken for granted narratives, the taken for granted conceptual categories erode and take on new form. And I think behind the sort of one of the great sort of central themes of this book, namely the co-constitution of the state on the one hand and the private corporation on the other, we see exactly that, the erosion of clear-cut notions of public-private, of veiled and open, of inclusion and exclusion. But that finally, thirdly, although that looks like a historical inquiry, when we actually think now about the changing conditions of 21st century global capitalism and its relationship with the legal and geopolitical order, it's precisely this kind of inquiry that opens up, allows us to start to reimagining what might be the conceptual categories that we need to make sense of that order. So they're my three very brief opening points. So partly, well, very strongly historical, very strongly conceptual, but also of great contemporary relevance, I think. So let me hand over, without any further ado, to our distinguished commentators, I think beginning with Bhupinder Chimney.
Thank you. Professor Chimney, we like to invite you to speak. Professor Chimney will say a few words about the changed approach of post-colonial communities to the regulation of transnational corporations and the question of turning to human rights framework. Thank you.
Thank you very much, Andrew. Good evening to everyone. At the outset, I want to thank the organizer for inviting me to be part of this discussion. I also want to warmly congratulate Professor Lustig for what I think is a pioneering and path-breaking work, which sets a whole new research agenda for all of us. I want to make just two sets of very brief observations. The first is more by way of asking for clarification, or I have some questions with regard to the general thesis of the book. And a second set of observations goes to addressing what, in my view, are the reasons why post-colonial nations were not able to have their vision of corporate accountability prevail. But to begin with, I would like to say that I entirely agree with the book's central thesis that direct responsibility of corporations was avoided through the what she calls the co-construction of the state and the corporation through, on one hand, the doctrine of sovereign will, and on the other hand, the doctrine of corporate will. The two questions I had in mind, so this is more by way of seeking clarification, was one was what was distinctive about sort of this phase of capitalism that accounted for the emergence of these two doctrines, because we know that there's been an intimate relationship between the modern state and capital from the beginning of at least the 16th, from the beginning of the 16th century. And the relationship between the state and corporation in the days of the charter companies was out in the open. So what was it that made this transformation necessary from the point of view of the evolution and development of capitalism itself? So that was one question that I had in mind, and the second was, I was wondering if Professor Lustig has looked at the impact that the emergence of these two doctrines had on the international law of state responsibility, which denied the possibility, in my view, of even making corporations indirectly responsible, through the doctrine of attribution. So I felt that in a book, while she deals with other aspects of making corporations accountable, she does not address, the evasion of the international law of state responsibility insofar as corporate accountability is concerned. These are more by way of questions. I myself don't have the answers, so I'm looking for it. And then I briefly turn to the other question about what went wrong, so that the attempt by post-colonial nations to make transnational corporations accountable in the 70s did not become possible. And in fact, Doreen writes in the very opening pages, and in fact, she charges the post-colonial communities of using the very international legal building blocks that were used against them to try and make transnational corporations accountable. And that is correct as far as it goes in descriptive terms. But I think perhaps there is a need to acknowledge here sort of the constraints that were imposed by the structure of an imperial world economy, along with agencies like the international financial institutions that did not really, that very much constrained post-colonial nations from pursuing the path that they had chalked out in the program and declaration of action on the new international economic order. And what were these constraints? I'm acutely aware that her book ends at 1981, but my sense she says that Doreen has dealt with several developments afterwards. And I think those developments afterwards are the key to answering the question as to why post-colonial nations could not pursue their own agenda and moved on to the discourse of human rights or to bilateral investment protection treaties and so on in an effort to constrain the transnational corporations. So here's my own take, which I think deserves more attention, that the developments in the very early 80s, which she has mentioned in the book, but not developed, beginning with the commodity crisis in 1982. And this was one of the most serious commodity crises that developing nations had faced, where the prices of primary commodities had fallen to lower than they were in the course of the Great Depression. This was then, the commodity crisis was followed by, and was at least one of the causes of the debt crisis. The debt crisis affected not only Latin America, but parts of sub-Saharan Africa and some other nations. The combination of the commodity crisis and the debt crisis sent the developing nations to the international financial institutions. We must remember that till this point of time, developing nations are very, very hesitant to go to the financial institutions, particularly the IMF, for loans because of the conditionalities that they had been critiquing. And the financial institutions set up a structured adjustment program, which meant opening up to, among other things, foreign direct investment. Meanwhile, the debt crisis and the primary commodity crisis meant the lack of domestic resources to pursue the development agenda that they had in mind. And it is after this point of time that you see the growth of bilateral investment protection treaties signed by global South nations with the developed nations. It is at this point of time that they become more actively involved with, say, the International Center for the Settlement of Investment Disputes. In other words, this alternative path that was pursued by post-colonial nations were not willingly pursued, but were pursued because of the circumstances that they were placed in by the global economy. The other last point that I want to make is, but it is not as if the developing nations gave up on their agenda. I think one of the things that needs to be pointed out is that while the Code of Conduct and Transnational Corporations was not adopted in '92, and it's true, was abandoned, some of the battles with regard to foreign investment were now fought out in a different forum, and which was the 8th round of negotiations leading to the creation of the WTO. So if you look at the negotiations from 1986 onwards in the WTO, the developing nations opposed strongly the TRIPS text, that the intellectual property rights text, and for 2 years they refused to even negotiate it. Likewise, they opposed the General Agreement of Trade in Services, which is essentially about foreign direct investment in services, and said that it should be part of a parallel track. Then again, in another completely different forum, say the Law of the Sea negotiations, developing nations fought battles with regard to transfer of technology, etc. So my sense is that the post-colonial nations, on one hand, given the constraints, had to abandon the NIO agenda, but at the same time, when we say abandon it, they did not entirely set it aside, but fought battles in completely different forums, which became the more central forums in the 1980s. So in short, I felt that perhaps a little more elaboration, again recognizing that the book ends in 1981, needs to be paid to the nature of the imperialist world economy and the constraints it imposes on close colonial nations. And there are a whole range of other factors. Then comes the end of the Cold War. There is no alternative ideology, etc. And I think these reasons need to be elaborated, and at the same time recognize that developing nations did fight other battles equally important in other forums. Thank you so much for your time. I'll stop there.
Great. Thank you very much indeed. So if we move on now, we've got clearly some very interesting and fascinating questions to follow up, or for Doreen to follow up on for us to discuss. But let us move on to Megan Donaldson.
Lovely to see Benedict and everyone, and it's a wonderful pleasure to be here and celebrate Doreen's book. I'll just be quite brief. I wanted today to say something about what this book does by really capitalizing on the way it works through these highly specific case studies, which offer us, I think, windows into the ongoing development of the architecture that Doreen's talking about. And each of the case studies that she presents both take this architecture, this sovereignty property distinction, seriously as a force in the world. They look at the complex effects of the sovereign and corporate veils interacting in different moments. But the case studies also recognize the constructed and sometimes fragile nature of the distinction and the co-construction of the state and the corporation. And the approach that the book takes pulls to the fore, obviously, the perspective of lawyers and judges and officials who are grappling with these matters. And it really proves fruitful, I think, and provocative for a number of reasons. It moves us very quickly across fields and institutions and concrete problems that are often treated in isolation. And it really brings the reader into the texture of the reasoning process. So seeing lawyers grappling with how to characterize particular entities and relations reminds us, I think, there's something really unmasterable here, both then and now. So I find this a mode of analysis that in its specificity, in the way it's anchored in a particular context, particular moment, unsettles us in the present, sparks thinking about the present. I just pause here to open a bracket. It might be something that Doreen will deal with in responding to Professor Chimney, but I take her account to be agnostic on the underlying drivers of what's happening, or at least open to different kinds of accounts of what's causing things to happen. It's an account that can accommodate a materialist narrative and argument, even if it is analytically, I think, quite focused on the precise workings of the superstructure, as it were. So let me say more about what I think the case study approach brings us by looking at the Industrialist Trials chapters. So these are chapters 4 and 5, in a way the center of the book. These chapters take up the architecture at a moment of intense innovation. So innovation, both in the sense that there are crimes under international law and in the articulation of the crimes themselves. And as Doreen notes, this turn to criminal law has complexities built into it already. At least for the liberal legalist mind, criminal law involves a highly individuated notion of responsibility. And to get to that individuated responsibility, one needs not only some device like conspiracy or complicity, but a theory of the structures of authority in which the individuals are operating. It's a problem still with us today in modes of liability jurisprudence. And the book shows that the theory underlying both the main Nuremberg tribunal and some of the key industrialist trials is thin or distorted or absent. So the tribunals did not grasp the nature of the Nazi state, the extent to which its deformalized corporatist character made major armaments and chemicals concerns central pillars of the overarching project of aggressive war. And both the prosecutors and the tribunals faltered in confronting criminal responsibility in the corporate context. They didn't charge the corporate persons, and in the end, the presence on the scene of the corporate actor, which is the thing that made the range and routinization of the crimes possible, made it harder rather than easier to get at the individuals who, by virtue of their high office, knew of the conduct and maintained the machinery which carried it out. So for all the emphasis in these trials on personal responsibility, actually, the analysis of personal responsibility was impoverished because there was no sense really of the matrices of authority in which the individuals were working. Open another bracket here, I think, to say that I'm not sure criminal law is ever going to be adequate to thinking these themes of responsibility. And I also think that the sociological analysis is also open-ended. So we see in, for example, in the discussion of Tooze's Wages of Destruction, that these questions about where authority lies, where the impetus was, are still open so many years later. But regardless of whether or not there is a right answer, the fact that there wasn't much grappling with whether there's a right answer in these tribunals had real effects. It produced impunity, and it's had long-run effects on international criminal law. So that's the effect. It's a powerful analysis of effects, but I also find interesting the account of the intellectual construction of the state and corporation that's going on here. The chapters take us through the prosecutors' conscious efforts to understand the nature of the Nazi state, their work with the analysis of Neumann, for example, and also the way they develop different theories in different trials of the conspiracy. But these chapters also capture the questions that are really hovering at the edge of the explicit theorization. And these are questions about the liberal state and its relation to corporations. We have in the background Lenin's thesis in imperialism as the highest stage of capitalism. And we have in the economic analyses of Brady and so on a concern that in fact, as the preface to Brady's third book says, capitalist economic power constitutes a direct, continuous and fundamental threat to the whole structure of democratic authority everywhere and always. So there are these shadows to the thinking. And the chapters suggest really convincingly that the American answer to these questions of what divides the pathological Nazi corporatism from capitalist democracies is cartels, is monopoly practices. That's the pathology. And it's this production of economic power, a concentration of economic power that fosters mutual reliance between state and corporate interests. There's definitely an intuitive logic to this. It obviously appeals to the sentiment of American progressivism that we saw in the interwar period. But we know that there were monopolistic concentrations in Britain and the US as well. And in fact, it had been a highly public, highly discussed feature of the relations between British and American governments and their armaments manufacturers in the 30s, that there were these problematic, possibly pathological connections between corporation and state there too. We also know that one of the fears that the Americans had about cartels is the way that they had been used by German interests to weaken or neutralize American competitors for commercial and geopolitical gain. So as the chapters bring out, decartelization is a move to break economic power, to sever it from the state, but it's also a way of preserving geopolitical interests, right? Protecting the interests of other states. And we're here getting really close to the contradiction that we saw in the armaments debates in the 1930s. Citizens and governments in the US and Britain are very alarmed by concerns like Krupp, which have this intimate dynastic relationship with German elites. But they're equally alarmed by a vision of corporate actors that, although they might hold one state's military secrets, then are indifferent to national affiliation, go off and seek profit anywhere else, as they are in fact machines set up to do. And Doreen quotes a memoir of Josiah Dupois, recalling what he was told by the chief of the War Crimes Division in the US War Department. A lot of people in this department are scared of pinning a war plot on these men, the industrialists. There's no law by which we can force industrialists to make war equipment for us right now. A few US manufacturers were Farben stooges, and those who weren't can say, look, if participating in a rearmament program is criminal, we want no part of that. So the liberal state here both wanted and needed a way to secure national loyalties from ostensibly rational, unaffiliated, profit-maximizing actors, and to construct something of that intimacy which had been so dangerous in the fascist state. And it's this dependence on the corporation which helps drive preferences for an artificial account in which the political and economic responsibilities are held apart. The book continues well beyond this point in the 1940s, obviously, but I stay here and underline this episode because for me, it's a vindication of Doreen's book and the history she traces, that the history does speak to us in different ways at different moments. And this moment in the 1940s felt very familiar to me. we're still, in some sense today, I think, caught in conceptual wrestling, which is analogous to the problems which existed in the 1940s about the liberal state and its relation with the corporation. And this is a lot for a question, so I don't pose it to Doreen as a question, I just say it as a series of things which suggested themselves to me and might spark something in you. It's clear that we don't have today the strong Soviet counterpoint, so the situation is different in that sense. We're all capitalists now, and to borrow a framing from the trade debate, international law might be less about managing the allocation between states and corporations as managing the coexistence of different ways of allocating responsibility between corporations and states, different varieties of capitalism, to use that terminology. But all the debate that we have now about a rules-based international order suggests a concern that liberal democracy in either its kind of liberal or coordinated market versions might be weakening relative to more authoritarian models. And we see this intense discomfort and confusion about the relation to the corporation, both as familiar national corporations go into new markets and make new political compromises, and as politics in the democracies is increasingly corrupted and dysfunctional. Corporations are clearly actors in this dysfunction, but they have also become vehicles for hopes of political emancipation or bulwarks for electoral democracy in the case of what's happening in Georgia. There's really a profound confusion here, I think. And it plays out for us as lawyers in this question of whether we go with a sociological understanding of power or stick with a formalist account, a state-first account, which doesn't have much grasp of reality, but nevertheless preserves things which are of symbolic or normative importance to us. So I wondered, Doreen, whether you had that sense of familiarity about the moment in the 40s or about some other moment in the book.
Thank you very much indeed, Megan. So should we move on straight away to, we're gathering a list of very big questions for Doreen, but let's move on to Tomati Koskinen now.
I just want to start by celebrating and welcoming this book. I mean, I'm among those, the huge crowd that has been waiting for this book quite a long time. It's absolutely great it's there. I hadn't seen drafts for some time. So also when I got this book in my hands, it wasn't quite the book that I had thought it would be. It's really a big and a heavy contribution. It's a wonderful thing to do. And when I was thinking what to say about it and from which angle to approach it, I was thinking, well, there are maybe three angles that that one could look at, and that maybe I should like to highlight the three critiques that you do here, each of which has already been, in a sense, mentioned by Megan and Chimney before me, but I want to just condense them. There's a historical criticism, there's a political criticism, and there's a legal doctrinal criticism. The historical thing that you do is a critical thing in as much as you start from the present situation of the doors opening to globalization. It's 1981, and something is happening. It's 1 year away from Reagan, and then we know what's going to come. And the narrative that you produce then suggests to us that what we are facing in 1981 is a repetition of a series of failures that you portray to us that seem so familiar to us. There's a failure of formal imperialism at the end of the 19th century. There's a failure of the civilization process. In the Firestone case, you showed it so clearly with the international institutions that we have. There's the failure for institutions and law to grasp Nazism and the nature of the Nazi state, as you showed to us. And then there's a failure of the new post-war system to grapple with the global inequality and the new international economic order. All those failures accumulate one after the other, suggesting that as the doors then open in 1981, it's the same garbage that then falls onto our lap, which we have witnessed de facto. So it's a wonderful genealogy, a wonderful historically based critique of globalization. Then there's the political criticism. And the political criticism is, as Megan was also highlighting, on this ambivalent relationship in the liberal state between the private and the public, or property and sovereignty, as I would want to put it. And as you show, there is this devilish logic about them that every time you think you get the power, it's already elsewhere. You think it's private. Ha! No, it's somewhere else. It's in the public realm. There's a state and there's a military force and there's a gunboat over there. And then you think it's the public realm. It's the state. Well, of course it isn't. It's the private entrepreneur. It's the private company. It's the property owner that stands there. And so that suggests, I think, what is a new understanding that's emerging, not only from your work, Doreen, but from general works at this time, that the whole separation, the conceptual world where we keep these two things distant, somehow prevents us from grappling with power as it comes to us, as we meet it. Because it always seems able to play that double game, never to be where we think it is. So, and that's a great achievement. And the last one, I think, is the legal doctrinal criticism. And that's the latter part, I think, of the book, where you go through the different efforts, the different vocabularies through which international lawyers have tried to grapple with that ambivalent phenomenon that's half public, half private, etc. You show that the theory of the legal subject, that doesn't really work. Then there's antitrust law, which I think this was new to me, and in the aftermath of the Nuremberg trials, the American theory of the corporation and the American antitrust lawyers whose intervention is so important and underappreciated, and which I now want to begin to study more closely in other places. But of course, that doesn't do what you want them to do. Then there's transnational law and Philip C. Jessup. And transnational law is very much with us. But again, you show that when it was first introduced, it wasn't clear what it was supposed to do. And I suppose, and I suggest that it doesn't really come with anything emancipatory. It doesn't have any project of its own. It's just another technical vocabulary, which also plays its own double game, new and old at the same time. Then there is the whole project of multinational corporations. And being of the age that I am, I, of course, remember very vividly the 1970s and early 80s when transnational corporation, the very idea, the very word signified some large thing with which we then tried to prepare ourselves to fight against and grapple with, etc. And all of a sudden, we were faced with this idea of self-regulation and soft law rules, and I think your skepticism about that move to self-regulation, the Global Compact, Ruggie, and so on, that's a real disappointment. And if you try to pretend that it's anything else, then I think, well, you just don't get it. And then there's human rights at the end, and of course there's now much literature. You don't go to it because it's no longer part of your period so much, but the human rights and neoliberalism nexus, which you suggest emerges quite naturally from the earlier narrative that you produce. So historical, political, legal, doctrinal, all of this just comes crashing down. So that's great. But that raises the question, of course, and I'm the last person to ask this, but so what? So where do we go? And there's a lot of skepticism here and a lot of reason for well-founded skepticism that we learn from these historical experiences that you produce to us. Nevertheless, I think I detect, and this is my question to you, I detect there's a sympathy towards legal realism of sorts, maybe a legal realism that's aware of its own conceptual and ideological commitments. But when you treat Jessup, for instance, when you treat McDougall, there's a footnote where you say you're going to pursue study of McDougall and the Yale people. I'm skeptical about that, by the way. I'm not sure that's a good project, but I'd like to hear your defense of that project. Anyway, so I don't, not to prolong this for too far. So I think this is really something that everybody needs to read. I look at how many people are here now listening to this. So I think, well, everybody's going to read this. It's the real crash on the Christmas market, I've no doubt. So congratulations, it's wonderful. Thank you.
Thank you ever so much, Marty. And again, let's move straight on to Glenda Sluga.
Okay, thank you so much. And I just want to second the enthusiasm of the other commentators for the book. I was so excited to find out about it by virtue of being asked onto the panel. I am an historian, and so I'm not an historian of international law by any means. And I've really enjoyed, reading the book and listening to the commentaries, partly because I'm interested in interdisciplinarity and just how IR, international law, and international history as the three international, what I call the international thinking subjects or disciplines, speak to each other. And increasingly we are learning from each other and the different histories that we do. And of course, your history, Doreen, is built on a historiography that's accumulating, whether we think of the historiography of chartered companies or indeed of the new history of capitalism. And, I enjoyed looking through the footnotes and finding all the historical work that, I know and I'm interested in, and seeing how it gets worked into this really fascinating picturing, if you like, of kind of the landscape of international order. Just to return to Andy's beginning comments, what interests me in this is both how you utilize history and also the picture, or to borrow from Megan's terminology, architecture of international order gets, it shifts because of the picture you've put together and the way you've drawn on these different histories. And in particular, I think for me, looking at and understanding the different sites of international lawmaking in relationship to corporations and how that affects our understanding of the state. I kept thinking, how does this change how I think about the state? And my own interest is in economic actors in the international domain. And so understanding how law becomes a kind of determinist, has a determinist agency in terms of how we understand, but also the kinds of power that corporations or economic actors can utilize in this international order. So I really enjoyed the journey of kind of revisiting kind of key historical moments and narratives and seeing how you rework them and how that changed my understanding. And so in this context, I think veiled power considerably nuances our understanding of the overlapping and intersecting spaces of the domains of politics and economics within the state and in these interstate, transnational and imperial relations. And so often I think still in history, as well as the other disciplines, these are conceptually separated in both normative and realist accounts of international order. So it's a really valuable contribution to kind of deconstructing and reassembling this picture of international order, of ways of seeing the state in the international order and seeing beyond the state in international order. Now, so what I'm going to, what interested me in a way is that unfair thing of, what happens when we put in other histories and look at other sites of international lawmaking. And so it kind of comes back to Professor Chimney's earlier comments too, but in different ways. And a little bit like Marty, I'm going to, this is going to be about what I think your second book should be about, if you don't mind. So, so it really got me thinking about the new kinds of history, including the history I've been doing, and where they fit with your picture and the questions it made me ask. So, so what picture of the 20th century international order, once we weave the law back into our understanding of that picture, law as an instrument of the organization of political authority and agency. Now, the sites that you pick are, ones that are being now reworked by historians through an emphasis on the agency of individuals in the way in which, of course, international law has also been reworked. And I noticed in the book there are a lot of mentions of international lawyers, but less kind of interest, kind of an eschewing of prosopography, right? So I thought maybe you could talk a bit about that. And I wondered if one did spend more space and time reincorporating individuals, that there wouldn't be, one wouldn't see, there wouldn't be more kind of unveiling, if you like, of the kinds of networks that may have existed that would allow you to understand why certain strands of legal thinking are picked up and others are dropped, because individuals might connect certain institutions, whether it's the OECD in the later 20th century and the UN, or even the PCIJ. But, so who are these international lawyers, and how are they, lawyers operating within these corporations, within the states, within these other kinds of IGOs at different points in the 20th century? Does that body of individuals shift very much? Now, I ask this because this is really going to be my main question. And as I said, it might be an unfair question, but I am seriously interested in it. Now, in the historiography that is engaging economic actors, now you talk about, your interest is in sort of thinking about corporations as subjects or non-subjects or other kinds of, in other ways in this international legal order context. And you get to the point where in the 1990s, or from the 1980s on, corporations can be participants. They're participants, so you can see them actually kind of participating. But there is a new history that's trying to unveil, if you like, a different strand or a different side of international law making, and that is the bodies such as the International Court of Arbitration, which deals with corporations and states from 1923, and it's set up by a private, if you like, or an NGO, the International Chamber of Commerce. And I think that if one looks back at, if one takes a kind of sociological view of the international order through the 20th century, then much as in the vein of your book, we see this much more complicated and nuanced intersection of agency and authority, so that we don't have corporations and lawyers and international institutions and states, but actually these economic actors, corporations bound by these international bodies, operating as alternatives to IGOs, and then operating as increasingly powerful advisory bodies within IGOs by the 1940s, so that within a space such as the UN, the International Chamber of Commerce has much more influence as an advisory body than the EU even in the 1970s. So the picture that you have of the state is complicated in terms of economic actors, corporations, and the state can be kind of translated into the international institutions too, but also into the different sites of international law making. So we know very little about the ICA, and you do talk about arbitration tribunals, and that is in fact the term that gets used to talk about them, and they're London-based originally, and that's from the 1880s even. And the authority of these London courts take on international authority in terms of these very secretive, sort of non-transparent, shall we say, sites of lawmaking or arbitration. So it's a different kind of site. But yeah, so if we put that into the picture, then how does it complicate the narrative you have? But also, would you do a second book on it for me? Thank you.
Thank you very much, Glenda.
I think we can pause for 5 minutes, and then we come back and hear from Doreen, responses from Doreen, and then we'll move on to the conversation.
So I'm very humbled by this opportunity. I'm particularly moved to have my book launched under the virtual roof of the International Institute of Law and Justice at NYU, that was my home for such a long time, and remains my home away from home, as you can clearly see. None of this could have been possible without the special vigor, enthusiasm, lively spirit of my dear mentor, Professor Benedict Kingsbury. So thank you, Benedict. I really had the great fortune of being Benedict's student. And he took me from the very first day at NYU by the hand and has been my mentor in the most deepest sense of the word. Benedict's commitment to searching new horizons, the quest to make the unnoticed noticeable, and the audacity searching for something one cannot be sure is really there, just because it may make a difference. All of that shaped my understanding of what it means to engage yourself in scholarly work. So more than anything, I think Benedict helped me find my voice and encouraged me to use it. So thank you, Benedict, for everything you've done for me and for this very, very special event. Thank you. I also would like to thank my dear friend Doreen Lustig for her really superb organization of this event and her thoughtful attention to every detail and commitment to finding the right forum and the right commentators. And she did a splendid work, and thank you so much, Doreen. I also wish to thank Professor Harl, who was also the co-editor of the book in the Law and Governance series, and Professor Dick Stewart, who's here with us, is also one of the co-editors. So thank you for your remarks and for moderating the session. I also want to thank the 4 wonderful commentators who carefully read and offered insights and ideas into the book. So Professor Chimney, thank you for your illuminating remarks on post-colonial approach to the question of the corporation, the way it shifted and what have motivated it. And thank you, Megan, my dear friend. I'm deeply grateful for your insights on the themes and methods of the book through the prism of the Industrialist Trials. And thank you, Professor Sluga. It's wonderful to meet you. I've read your work for so long. It's wonderful to at least see you virtually. So thank you for your remarks and questions and the conversations I hope we will have in the future on the ideas that you've mentioned. Last but not least, I'd like to thank Professor Tomati Koskinen, who has been my very close mentor and friend and teacher throughout various twists and turns of this project. Marty has read numerous drafts and encouraged me to pursue the book project, and his enthusiasm over new discoveries and possible arguments made this journey the meaningful journey that it is. So thank you, Marty, with all my heart, for encouraging me to explore this kind of longue durée narrative and for thinking everything I know anew. I really couldn't have done this without all of you, so thank you. I'm very grateful for the rich commentary that we've just heard. I really cannot possibly do justice to all the question and I want to take time to think about them. I'd like to say a few words on the book itself and engage a little as far as I can with the comments that we heard. So just in kind of very briefly, today corporations have enforceable international rights under international law, and in contrast, they are rarely subject to any enforceable international obligations. And the usual narrative we usually associate with this legal reality is a narrative of failure that Marty echoed in his talk, the failure of international law to recognize corporations as subjects of international responsibility and a failure in various other respects. In the book, I try to complicate this failure narrative. I try to reveal the central role that international law has played in the history of the private corporation. I argue that far from failing to regulate corporations, international legal doctrines, practices, institutions constituted I would use Megan's word, the architecture of the legal order that proved pivotal to the operation and flourishing of private business corporations. And the book explores the ways in which the normative shift towards state-centric international order, and that moment of shift is what I guess Professor Chimuni was asking about in the late 1880s. So that shift to state-centric global architecture, I tried to suggest, proved quite beneficial for business corporations. So as Megan suggested in her comments, the book centered on the intricacies of what international lawyers and the specificities of their own recognized world. And the question of corporate responsibility, to the extent it was on the table of international lawyers, is what I sought to unravel and to see how they grappled with this question in various dimensions and contexts: natural resources, slavery, criminal law, etc. And that may be the answer to why I in that particular using that particular methodology, following the recognition, the rule of recognition, the recognized world by international lawyers to unravel their blind spots, I wasn't perhaps able to explore further the very intriguing arenas that Professor Sluga asked me about. These arenas were not at the core and central debates of international law on the issue of corporate responsibility, yet I think these arenas are immensely important in understanding in a much broader and more rich way the ways in which corporate actors operated, influenced, informed, and shaped international law. I would even say that in my current work, which is more focused on international lawmaking processes themselves, I can see the great potential of looking at corporate actors as actors behind the scenes or not so behind the scenes in international legal lawmaking processes. But this wasn't really the main theme or concern that I was tracing when I looked at the work of international lawyers and their debates in the context of corporate responsibility. But I think it's a very, very promising venue, and I'll explore it further. So thank you for that. The book, rather than looking at these arenas, as Professor Chimney noted, centers on the interplay between the state and the corporation. And even though it was mostly or almost always beneficial to the powerful, it wasn't always the case. So I think one of the surprises or one of the aspects of the book that made me unstable in some ways is to see the ways in which not so much post-colonial countries utilize the international law that was dominating them, but actually strategically were able to use the rigid attitudes of the veil of the sovereign state and the private corporation to work against the interests of powerful states and corporations. So I think that what's quite intriguing is to see the ways in which in some instances the corporate and sovereign veils actually served to limit, for instance, the scope of diplomatic protection conferred on companies from the global north, enhancing the prerogative of the new sovereign states to regulate assets and corporations that were operating within their jurisdiction. So actually the rigid adherence to the principle of the corporate veil and the separation between ownership and control at times, not always, but at times, empowered decolonized nations and strategic actors in their struggle against the influence of foreign commercial and political power. So of course, the fruits of these challenges did not always remain ripe or didn't really remain ripe for long. So in the book, rather than thinking of the private business corporation as excluded from international law, I try to emphasize how international legal doctrines in various contexts directly inform the regulation of private business corporations in global settings. So, and if I may use Megan's question about the contemporary moment, or Marty's question, so what should we do about this? So what does it mean, and where do we take it from here? So I think that the book ends at a moment of transition in the history of international law and the private corporation, and I would definitely follow Professor Chini's suggestions on looking at the kind of pursuing the following decades more closely. And the emergence of international investment law, for instance, regime marked that transition to the corporation as an equal litigant who can independently protect its rights at the international terrain. In addition, the transition to corporate social responsibility as a central regulatory framework for questions of corporate duties. I agree with Marty that was in various ways a low point in terms of the prospects of corporate regulation, but was also a moment that, if we think about it conceptually, constituted maybe not but this moment constituted the corporation as a regulator in and of itself. So when self-regulation is exercised, or at least as an equal participant in public-private codification projects like Ruggie's Global Compact. So it was a moment of clear empowerment of the corporation on these various international terrains, and that at the earlier stages of this transition, we had a vibrant anti-sweatshop movement in the 90s, and we had the Seattle protests, and we had an attempt to think about the problems and critical aspects of this new phase. Yet ultimately, this period was probably the time during which the failure narrative that I'm trying to challenge in the book came into being and gained momentum. And this failure narrative reinforced the great influence of corporate actors rather than undermined them. So are we still stuck in that moment of persistent sense of failure? So I'm not sure about the 1940s, but I think that there are actually reasons for cautious speculations that some things are maybe changing. So maybe it's because I'm in this kind of celebratory mode that I wish to end with some optimism and ideas about how the future can actually be better. But I do think that the debate over a new architecture for the international law regime may have some potential, and the reemergence of progressive sentiments that we haven't heard for so long since Reagan and even before are now beginning to gain traction. And so it may have to do with the sense of crises that we all experience, but still I find them quite fascinating. And I wonder whether the new cases that are being held in different courts around the world, transnational litigation of corporate responsibility in the context of climate change and human rights, whether that maybe is part of, these are part of a few examples of a potentially new phase, maybe, in the relationship between international law and the business corporation. So I'm still quite puzzled by the meaning of these developments, and I'm very curious to study and investigate the questions that you posed and the questions that these developments may pose. And I hope to build on the historical background that I explored in this project and take these themes further. So thank you very much, everyone.
Well, I'll just add one comment, Doreen. I've just come from New Zealand and back to the US, and there's a phrase in the Māori language, which also a sensibility, which is about kind of going forwards, but with our face to the past. And of course, the face to the past is the emphasis from the historical side and the way the project is framed and presented and discussed. But the kind of going forwards it's the daily life of lawyers. And I think that's what you've just been addressing. And many of the comments were also naturally towards that. And so one thing is to fill in, as it were, trajectories that are just where the book itself stopped, or perhaps to go the precursor elements or the other paths, side paths of the time. A different thing is the sense of where things are going, where one's walking to. And about that, I have a question, really, not so much to call you to answer, but whether the corporation is a continuous ontology here in this work. It's the phrase, of course, has that implication, but is it actually the experience of studying them? The phrase and the form corporate is an ontology which captures something constant over time. And thinking of where things already are and have been a long time, in fact, and they're going, I think this is perhaps a little response to Marty's framing a direction about property and sovereignty. I think there is a third pretty big element, which is contract. That is the make it or buy it kind of choices that all corporations make. What should be in the corporation and what's not in it, but it can be organized by other means, usually contract. So sometimes other forms too. And there's one branch has gone towards networks. It doesn't have such a satisfying vitality, but to try to capture something there of the changes in what a corporation is and what it does and how it does it, and what's significant then, where the power is, which might be neither in the corporation itself nor in the state itself, but perhaps in the zone, which is often loosely phrased by contract, but there's much more there. So that's one kind of question. Is it there? Some of the work I'm trying to do is on infrastructure, which is trying to look below that, things which are continuous but aren't just in the corporation or just in the state either. Things which may be so embedded and cemented sometimes that they don't seem to be for anybody exactly. And I think that's a different kind of path in the biopolitics of path there to things which are important and involve power, but aren't quite what anyone designed or thought. So that was one element of this. And I think a second element of the going forward is to what extent this framing is still quite a North Atlantic one, and how far that's going to sort of remain the dominant form. How far is anything different going to be thought as power shifts to, of course, to China, to Asia, to Africa, and to other ways of thinking and organizing other things that are important, which the digital data is one. So that was quite a vague, circumlocucious kind of enterprise, but it's really to try to capture what thoughts one might have to take from this, kind of walking backwards into the future. And with that, I think we should launch into a free-for-all set of comments, should we? In a wildly anarchic way, and certainly if I'm involved in it, it's bound to be that. But my screen, and the screens are wonderfully different, which is a kind of glorious anarchy of the Zoom system. But I see first Ben Heath, and then Rob House, and then Alana O'Malley. So Ben, did you like to go first? Should we just hear a few people and make some comments and we can provoke each other? Ben.
Sure, thank you so much. Thanks to everybody for these rich comments. I'm sorry, I am displaced from my apartment for a few hours, so I'm outside. So if there's traffic noise, I apologize. But this is a fascinating discussion. Benedict's comment got me thinking about this idea of the corporation as continuous versus sort of discontinuous over time. And I wonder if there's a deep way they are continuous. So maybe push back, but maybe we're saying two sides of the same thing. You know, the idea of individuals came up in this discussion, right? Individuals, maybe communities. Recently, Nicholas Perrone has done a lot of work around affected communities in the world of foreign investment. And one problem is, in order to sort of be heard at the international level, whether it's in an IO or whether it's in a dispute, they need to be organized in some way. And that organization tends toward a corporate type form, right? You get something like an NGO, which has some sort of board of directors or such and such. And I wonder if, like, even beyond the corporation, corporate organization is this intractable grammar of the system that is not actually as easy to disrupt as maybe even the central power of corporations. But I just wanted to throw that out there as part of, as Benedict said, the free for all.
Thanks, Rob House.
First of all, to Doreen, congratulations on this magnificent achievement, and so many themes to provoke serious thought and further scholarship. And along these lines, I would very much like to see eventually a sequel, chronologically taking us from where you leave off to the present, because in a way, I think that what has developed is what I would call, a second or maybe even third veil. And what I mean by that is that if you look at the last 2 decades, the trend towards a private equity, towards structures where a small group of individuals manage the wealth of very wealthy people, and directly affect the activities of quote unquote corporations. In doing so, even the so-called Dutch sandwich, which at the same time is a way of inventing or reinventing corporate nationality to avoid tax, but also expand investment protection under treaties. All of these might be described as second or third, veils that affect, in many ways, international or transnational economic activity and power. And so I think the spirit of your work would suggest that the value of scholarship that tries to identify this phase of what I would call the second or third veil. I also wanted to riff off of Benedict's comment about contract, and I noticed that you do talk a bit about the theory of the firm and how the theory of the firm becomes, in terms of the business school understanding of the corporation, dominant, which of course is to understand the corporation in terms of a choice for internal over external contracting. And I think intellectually and ideologically, that idea has a considerable significance, because it makes, in a way, institutionalized power almost disappear, such that the problems of governance are really a matter of controlling the agency costs of contracting and things like information asymmetries.
Thanks, Rob. Ilana.
Yeah, I just wanted to say thank you so much for such a superb book, and I was delighted to stay up all night reading the chapter last night. I just have 2 questions really related to the UN, because you focus a lot on that. I'm a professor of UN studies at Leiden University in the Netherlands. And the first question is about the human rights rationale. And I'm wondering if you found any evidence for the earlier emergence of the human rights rationale as a reason to regulate the behavior of private corporations. You named 1965 as a starting point for UN attention towards this. But I think that actually ECOSOC discussions, particularly those that are subcommissions of ECOSOC that are dominated by Global South countries, even before the great moment of decolonization in the early 60s, are already talking about private actors and regulatory mechanisms that may be required, given that self-determination and economic sovereignty become bound up together in the human rights debate about the covenants in the early 50s. And also the kind of further rationale from this comes from the finding of the Security Council in 1961 that the activities of private corporations remain impervious to UN Security Council regulations and resolutions. So I'm wondering if that human rights rationale appears earlier. And the second part of the question is for the later chronological period. So after the 1960s and after PSNR, is there not also a tension between this effort to regulate the behavior of private corporations, but also the reliance of Global South countries on them to continue their activities, given that they're not just in the extractive industry, they also own, vast tracts of infrastructure and of land. And that kind of raises a whole series of new questions about how to make those companies redirect their profits to Global South countries themselves. So it's a different type of regulation than perhaps is sought in the early part of the period. So just two questions. Thanks very much.
Is anyone else who wants to make a comment now? And
Love Ronald wants to...
Yeah, hi, Love, please go ahead.
Thank you so much. I'm Love Ronald and I'm at the Institute for Global Loan Policy at Harvard Law School. And thank you so much, Doreen, for the presentation in the book. I found this incredible, the excerpts that you sent out for this. And I was sort of following along in the discussion and thinking about how to take this further. And I've recently been spending a lot. Sorry, the fire alarm is being tested here. Yeah, so I've recently been spending a lot of time reading Katharina Pister's Code of Capital book, which tells like a very much more sort of private law centered story about corporate power. And I was thinking now, reading your excerpts in particular on sort of investment law emergence and so on, to which extent there's a sort of way forward, like merging those two narratives a bit. I think there's a substantial like undergrowth of things like export credit insurance, political risk insurance, investment insurance, debt collection, third-party funding that are sort of sustaining many of these kind of corporate rights. And it seems perhaps to me that the Katharina Pister book is undervaluing a little bit the public international law, sort of the transnational property side of it that's in your narrative. And also I was somehow feeling that, adding all those things, that undergrowth to this story would create a more kind of powerful story of corporate actors. Then of course that might lead to sort of the lure of technocracy, and that project might be lost. But I'm not sure that I'm that worried about that. So that was my reflection on your fantastic book, and thanks for sending out the excerpts. That was a true treat. Thank you.
Also, Glenda, Marty, Megan, Professor Chimney, if any of you would like to weigh in, even just to debate with each other. This doesn't have to have too much of the fix it and fig leaf of big advice to Doreen. It can just be a discussion.
Maybe I will just say something prompted by that immediate comment. I mean, one of the really fruitful aspects of these case studies is precisely the way it sets your mind thinking about what other case studies might have been in there. And I guess prompted by more contemporary developments, I found myself thinking about things like sanctions, right, which are somewhere between the private and the public. So there's obvious things like we could talk a lot about the trade regime and how we think about subsidies and things like that in terms of the identification of the corporation with the state and different approaches taken to that in different systems. But the sanctions is one obvious thing, and there are simply so many other areas of interface or areas of law which call for some theorization, which is almost always under the surface, that we could add to this picture.
The one comment I wanted to make to Doreen and maybe to ask her about, for example, my mother was a slave laborer in Auschwitz, and that's how she survived. And AG Farben, which was dismantled by the Allies, but then by 1951 they let all the directors that they had charged out, but the corporation was never charged. And it struck me, I lived in Louisiana for a little while, and the oil companies used to take barges for drilling in the wetlands and cut them up. So today it looks maybe like a puzzle. You know, there's lines, and the oil companies here never were held liable. Similarly, in Belgium never was held liable for what it did in the Congo. So these things strike me as very peculiar, but also someone mentioned, I'm sure, I don't recall which commentator it was, but that the U.S. War Department didn't want to pursue corporations because they were concerned that their corporations would be charged. So, and here we are many years after that, 60 years or more, and hundreds of years in the case of Belgium, and still corporations are not being charged. And they, in essence, as you point out, I think in your introduction, they're basically running the world as opposed to states, or at least that was my interpretation. So I wonder if you have any comment about that, and I will mute myself. Thank you very much.
Anyone else like to make a comment now of any sort, and then after this, we'll see what Doreen wants to say, and if she wants to answer any of the bits and pieces of what's been said just now. Okay, Doreen.
So I assume that after an hour and a half on Zoom, everyone is quite exhausted, and I'm really very grateful for everyone who's been with me so far. So I'll just make a very brief few comments on the questions that I've been asked, and so I think the one big comment, I think, Benedict, I heard you suggest, or the ideas that you were highlighting, was whether should we stick with the ontology of the corporation, the puzzle behind the ontology of the corporation, is the ways in which it veils in some ways power relations that we aren't able to appreciate, or should we seek those power relations elsewhere? I hope I understood your comment correctly, and I think that's a very interesting question. And it also relates to Rob's wonderful comments about the theory of the corporation, the theory of the firm, and the ways in which it ties to ideas about contracts. And I think that in this project, I try to shy away a bit from the ontology of the corporation as my main intellectual arena with which I'm grappling, and looking into practices of lawyers and their ideas and their engagement with the corporate entity without actually ex ante having the theoretical framework inform the ways in which I understand their undertakings. Having said that, I think that it may be helpful at this point to think anew about the theory of the firm and try to see how that history and theory relates to the findings of the book. I may not find much promising findings there, but I still feel more prepared now in some ways. I feel that it's now that I have this background, it may be possible to think critically, agnostically, and without being too much infused by these theories as kind of predetermining my understanding of the relationship between corporations and other actors. So I think that maybe the time is ripe to revisit that intellectual history and see how it corresponds or not with the history that I try to unravel here. And I think so I guess that would be one answer. And I also think in the vein of what Rob was suggesting, that it is fruitful to think maybe through the framework and the prism of the veil on the following developments. And here it also alludes to the idea of looking at international organizations and other settings and the ways in which veils are operating in these settings. So I want to think about that and how to pursue such a project if that would be possible. I think that a lot of your comments actually, well, I can address them in two ways. One is that I think it's wonderful that we, as Marty mentioned also earlier, that we have a few books now coming out, or a few monographs and works that are trying to grapple with similar concerns from different angles. I can't really be so presumptuous as to think that I can actually cover all that terrain myself, but I think engaging with these projects is very promising, and I think, and it may attest to this kind of new critical sensibilities that we now share at this point, and I think that may be something we can think about when we see these monographs coming out relatively in the same time period. So that's kind of the intellectual historian understanding of what is going on at the present. So I think that's a very intriguing comment. And Elena, thank you for your comments. I think they're very illuminating. And I didn't want to look at the history of human rights more broadly. I looked at the very particular regulatory project of the code, but I think it's valuable to think about it in the broader context that you suggested. It's conflict. Thank you for your suggestion. I guess your puzzle was my puzzle in many ways, and kind of motivated my investigation. So thank you for kind of flagging it so nicely and putting it forth in such a brilliant way. Thank you. So I think I can't really do justice to all of the wonderful comments and questions, but I just want to say thank you for raising all of them and making my journey even richer for the future. So thank you very much.
Well, I think it's been a really fitting panel, a wonderful panel for a wonderful book. And our speakers, it's really kind of you to take the time and put the effort to joining this thing. And for those who haven't had a chance to read the book or not much of it yet, I think you'll find you really get a lot out of it. And it's something which stimulates so much other thinking is a real kind of measure of what this kind of scholarship should be about. So we all congratulate Doreen. I think for those who've been academics have been doing it for quite a while, it's one of the joys to see a student arrive and be thinking what to do and starting to shine the torch down different paths, get deeper and deeper into things and learn more and more, kind of start to think new thoughts. Then quite quickly, in Doreen's case, be thinking thoughts no one seems to have thought before. So and then to see that whole trajectory come around to the point where the person is teaching wonderful students themselves, who then show up with a whole lot of ideas that we didn't have, because coming from Tel Aviv to New York, etc. And then to see this splendid book and all it's going to stimulate, it's marvelous. As Corinne mentioned, that we hope that there'll be some sort of publication of comments about the book in Humanity, the journal, and also that people who get interested in still in the old-fashioned world of writing book reviews or blogs about it might want to engage with this. There's kind of vitality to this, and also a chance, I think, to stretch one's own mind and write one's own thoughts, kind of in dialogue with what Doreen has put for everybody. So it's really the real virtue of scholarship is embodied and embraced in this book, and I think we can look forward very much to Doreen's future projects, of which the list she has herself and the list she's now given constitutes probably 20 lifetimes work. so there'll be a little bit of choice and discrimination. So I think thank you again, Doreen and Rachel Jones, for the organising of our panel on this IILJ enterprise and this whole history and theory of international law series that Doreen runs with fantastic energy and vision. It's really one of the most satisfying things of being able to do this sort of, in a way, indulgent work, but is to see the real stimulating payoff from having a chance to sit and reflect and push collectively in this kind of lively exchange down these paths. So with that, I thank everybody, and I think we can stand adjourned, and congratulations, Doreen, and we look forward to the joyous success of this book and what you'll do next.
Thank you very, very much.